This is Colin O'Keefe here for LXBN TV. On today's episode, we are taking a close look at Georgia's non-compete law, and joining me to explain the basics with it and changes we've seen over the last couple of years is attorney Bob Stevens. He is based in Atlanta with Seyfarth Shaw, is an author on the firm's blog, Trading Secrets. Bob, first, I understand that this week marks the third anniversary of the Georgia non-compete statute. What are the biggest changes that you've seen in the law in Georgia since the passage of this new law?
First of all, Colin, thanks for having me today. Yeah, you're right. This is the third anniversary this week. May 11th, yesterday, actually, was the third anniversary of the new Georgia non-compete statute. The biggest change is, perhaps the biggest change is the fact that courts are allowed to blue pencil or modify non-compete agreements. Under the old Georgia law, if an agreement was overbroad, it was unenforceable, and a court couldn't fix it. Now a court can go in and mark through or modify it. Additionally, there's presumptions in the new law that the territory, for example, if you identify the territory as the geography where the employee is working at time of termination, that is deemed reasonable under the law and presumed valid, as well as time limits on time limits. So if you have a two-year non-compete, that is also presumed valid. And then if you limit the scope of activities to the services or products or activities that the employer performs while the employee is working there, that's also deemed presumed valid. So under the new law, these presumptions actually presume almost an enforceable non-compete. It's a significant sea change from the way the law used to be under Georgia, old Georgia law.
I see. And then second, have you noticed in your time as a lawyer any anecdotal changes in how the courts interpret restrictive covenants there in Georgia?
Yeah, no, that's a very good question. The reality is that under the old Georgia law, what we saw is most courts almost always found them to be invalid. Very difficult to get a non-compete or a non-solicit enforced. There has been a complete sea change. I've been in court multiple times on the new law, and the courts deem those, almost presume them to be valid, almost placing the burden on someone to try to find them unenforceable. And what you'll know, I don't know if you know this or not, Colin, but the law is not retroactive. So if the agreement was signed before May 11, 2011, you apply the old law. If it's signed since then, you apply the new law. So there really is a stark contrast between the enforceability of old and new non-competes in Georgia.
I see. It certainly sounds like this law did have quite the impact, and it will, of course, continue to evolve as time goes on. Once again, that was attorney Bob Stevens. He is with Seyfarth Shaw. For more of his insight and insight from his colleagues as well, be sure to visit tradesecretslaw.com. Thanks for joining me today, Bob.
Thanks, Colin.